Coming up on this program, we show you how to get connected. Find out how to choose an internet service provider. Discover the newest form of communication, electronic mail.
Ways down and ready to ride. One by one, billion by billion, and holding up half the sky. Raise your hand if you're ready and willing. If you know it's time. Time for a girl on time. Time for a girl on time. Time for a
I love it too, Vicky. I was toying around with changing it for the new year, but I thought to myself, what are the fucking odds of you doing that, Paisley? Don't waste your time. I hope everybody's doing well today. It is what is the date? It's Thursday, December 19th. And I know what day it is. I hope that you're doing well. I have a lot of baking that I'm going to be accomplishing over the next probably like 16 hours. And so my mind is all consumed. Butter, flour, sugar. Oh my. Also, they're out of icing sugar. Terrible. I'm gonna have to look everywhere. Hi, Christopher Engelby. Nice to see you, my friend. Let's all take a little break though from our worries of the kitchen, our woes of the day, and let's kick one back together. Watch us a court case. Shall we? I think we shall. We're going off now. Honestly, I feel bad because the picture in the thumbnail, like, I caught her making that face and I did indeed make the thumbnail, so I am to blame for it, but I just laughed. Christopher! Yay! Thank you so much! It's amazing. That's the wrong button, Paisley. Sunday we will do members only. It'll be, I'm not sure what time at, but it will happen. Okay, downloads. Judge Kirkham. Let's get the case here, folks. My friends. Was it this one? I think it is. So we'll start with the title card. We'll start with the title card, but the judge didn't come in for a while. I probably should have started playing this a while ago. But
Yeah, because I thought Paul was.
I was still singing. We're just singing through your thing. Here we go. That's actually a blowjob technique, by the way, singing through your thing. Hi, Courtney. Hi, Sherry. Hey, Bill. Looking green. Love it. If I hit fast forward, it will.
Okay.
Thank you, Jesus.
Well, because I thought Paul was on, so I didn't.
Yeah, I just went by the TCS.
I didn't look and prepare for a bunch of stuff on that.
Please unmute, Ramon. Hello?
Hello.
Okay, hold on. Let me go ahead and open the record here.
Okay.
37th Circuit Court is now in session with the Honorable Brian K. Kirkham presiding. It is Wednesday, December 18th, 2024 at 1:22 p.m. for 2022-2792 DM, Ramon Guerrero versus Jerry Diaz.
Okay. Good afternoon to both of you.
Good afternoon.
This matter is before the court for the revocation of paternity on the child in this particular case.
I'm sorry, what? Revocation of paternity? Ramon is not the father to Jerry's baby? You don't say. I had no clue that's what this was about. But that's pretty serious. You know, the court looks at a couple different factors when they're talking about a revocation of paternity. Generally speaking, there's sort of like a time frame within which you have to make moves on that. They're really not very excited to hear people talk about older children that are being disputed. But we'll see what happens here. We'll see what happens. Yes, this is the Maury case.
Court notes that, just to clarify, Ms. Diaz, is that Shondell Porter was determined to be the legal father of Darren Porter. Is that correct?
Yes, we were living together at the time. So yeah, he signed Darwin's birth certificate.
That was back on 11/5 of 2024, so just about a month ago.
Yeah.
What I'm going to do is have you both sworn in. We'll take some testimony, and then we'll be able to proceed. So if you would both raise your right hands, be sworn in, then we'll proceed.
Do
Okay.
you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
Yes.
I'll go with you,
Yes.
Ms. Diaz, because you are the petitioner. You filed the petition in this matter. As I stated, there was an order of affiliation entered in this particular case. You have testified that you and the plaintiff had not been together for approximately 17 years. Is that correct?
Yes, sir.
So you can put your hand down. And so obviously when the child, and I don't have the child's date of birth,
March 6th, 24.
March 6th.
Yep, 24.
Somebody fucking run the books on when she was fucking. I bet it's more recently than me. Maybe. I mean, it was 9 months ago. I bet she has. Oh. Okay. We're not trying to be depressing today, Paisley. We are not. We are not. And I chase men away. Do you realize that? They run the opposite direction.
So that would have put, in this matter, would have put the time of conception approximately late May or June of 23. Is that correct?
Yes, sir.
Had you engaged in any sexual relations with the plaintiff at about the time of conception?
No, sir. I haven't seen Ramon in maybe 3 years.
Okay. Well, just for purpose of the record, I got to establish that at the time of conception.
Okay.
And in this case, has Mr. Porter accepted responsibility for the child? And does he accept the child as his child?
Sir, he passed away.
Oh, don't look at me like that, Jerry. Christopher was sending a lovely super chat cheering me the fuck up. You're telling me now that the real dad is dead? Oh my god. This is a roller coaster. We are on a roller coaster. And thank you so much, Christopher Angleby. That certainly brought a smile to my face. Also, look, the way she's looking at me, I can't handle it. Jerry, I'm sorry. Jerry. Please don't. Hi, Erica.
In September.
Okay, I'm sorry. Was not aware of that.
Yes, but he does know Darwin's his son, and he signed the birth certificate.
Okay.
Yes.
Darwin, you are kidding. It is a parody. It's a parody, right? Right? Is it? Now I'm fucking confused.
Okay. And so in your case, during the time that he was alive, in fact, had he treated the child as if the child was his own?
Oh, yes, he loved Darwin.
Okay. Okay, thank you, ma'am. Mr. Guerrero, in this matter, as she stated, you hadn't had any contact with her for at least 3 years. Is that correct?
Yes, sir.
So at the time of conception, which would have been May to June, early June of 2023, you were not engaged in any sexual relations with the defendant.
No, Your Honor.
Okay. Okay, thank you. I don't need much more than that. What we'll do is the court will find in this case that the minor child, Darwin Porter, is a child born out of wedlock, not issue of this marriage, and that the plaintiff is not the biological father, which would be confirmed by an order of affiliation entered on 11/5/2024, finding that, in fact, the Mr. Shondell Porter is in fact the biological father of Darwin. So I'll make that finding. Ma'am, when you filed this matter, did you submit an order as well?
Yeah, I had to submit the order to start the court.
Well, there's an order at the end of the case that you have to submit as well. And do we have that order?
I'm looking, I don't think that one was submitted.
Why is he involved? They must be married.
No, we do not have one.
Okay, I didn't see any when I was looking through the file. Okay, ma'am, you're going to have to submit an order in this case determining that the child is a child born out of wedlock, okay?
Okay, how do I do that?
Well, you're going to have to probably go to michiganlegalhelp.org. It's an online site. They have all the forms on there. It is a standard form, so it's not going to be complicated. And then you just fill in the blanks on the form and then submit it to the court, and then we will get it entered. And you'll need that for purposes of doing the revocation.
Okay, and that form is what?
That form it's called order after hearing on motion to revoke paternity.
Okay.
And so when you get into that, just go through the index and you'll find that. Then it's a fill in the box thing. It states when you filed the action, when we had the hearing, which would be today's date, that the court had determined that yes, the child was a child born out of wedlock, not issue of the marriage, and then we'll get it entered and that will conclude it.
Okay.
Okay?
All right.
Thank you. You're free to go. Have a good day.
You too, sir.
Have a good day. Thank you.
Okay. Do you want to go to the summary disposition? We do have the in-person people here now.
Ew.
Are you Mr.
Boo,
Little?
in-person court.
And are you Ms. Daniels? Okay. You want to do them first or the?
Yeah, why don't we do them first and then
Do her
do
in
we have
person,
to see about
Judge.
getting
Do her
them
in
sauced
person.
I believe I did see him. Hold on, let me send her a message.
Okay, just step up to the tables here. Miss Daniels, you can sit in the one right in front of you, and then Mr. Little, you can sit on the other side.
Judge, do you want me to stop the stream for this?
That's fine, yeah, because we're open, we can do that.
Boo, she said. Boo! Jesus, why did you cock block us? Damn it, Jesus. That's okay. He came back on later. Abruptly later, I would say. Was it this one first? Maybe this one first. That case was fucking crazy. That is the kind of thing that it's like you wrote it into Chat GPT. You're like, give me a weird looking case. Is this the same one? No, it's not. No, it's not.
I don't see a need.
Oh, Mr. Chapman's looking better, which is good to hear. Pardon me. Good to hear, even though I said it. Good to see. Sir, I've been told my whole life.
How many
uncross your
hearings
damn
do we
arms,
have so
Paisley.
far in this?
For FOC day,
Yeah.
by my count is 5.
So
I could be wrong.
they haven't increased then.
No. One moment here to open the record. The 37th Circuit Court is now in session with the Honorable Brian K. Kirkham presiding. It is Wednesday, December 18th, 2024 at 8:35 a.m.
Good morning, Mr. Chapman.
Good morning, Your Honor.
How are you today?
I'm doing well, thanks.
Good, good. Well, you can proceed when you're ready.
Thank you. Before the court is Matthew McCain of case 921346 DP. Mr. McCain is here today after failing to appear before the domestic relations referee on November 13th, 2002. Bond is currently set at $18,100. This is the first bench warrant. This case is now fees only. The arrearages, if I recall, are under $300 in fees. Front of the court's going to request that the bond be canceled, allowing Mr. McCain to be released. And at this point, I don't see a need in a hearing. I would request that Mr. McCain contact front of the court after his release to find out what he needs to do to finish
Okay,
this.
thank you. Mr. McCain, do you understand what the front of the court's asking for? They want to cancel the bond in this matter, so the court will grant that request and cancel the bond. But I will order that when you get released, that you would contact the front of the court within 14 days of your release from incarceration. So you're going to have to do that. Don't just get out and assume you don't have to do anything, because then you'll be right back here. Okay.
Okay, I'm just trying to say what fees I gotta pay because Allen County took it over in Ohio.
That's why we're going to have you contact them. If you contact them, they'll tell you everything that you have to do.
Okay,
Okay, thank you. You're free to go. Have a good day.
all right, thanks.
Now before the court is Allison Bowling of case 181752 DP. Ms. Bowling is here today after failing to appear before referee Snyder on March 4th, 2024. Bond is currently set at $503, and this is the third bench warrant. This case is now an arrears only case, and that's where arrearage is owed to the state. Front of the court has sent Ms. Bowling an arrears management program application and is requesting that bond be canceled in this matter, allowing Ms. Bowling to be released and that she complete that AMP application and return it to front of the court.
Okay, thank you. You understand what is being asked for, Ms. Bowling?
Yes, sir. I just moved into my new home March 8th. I was living in a hotel for over 9 months prior to that.
Okay. Well, it doesn't change anything, but what they're asking for is they'll cancel the bond. They've sent you all the paperwork for the again, arrearage management, if you would, in this particular matter. And so what you're going to have to do when you get out, you're going to have to make sure that you get that into the front of the court. All they're trying to do is help you to get this matter resolved. Okay. If you don't file the application as that they've provided you, and if you don't have it, if you lost it, go back to the front of the court when you get out, get another one, fill it out, get it to them so that they can assist you. If not, there's gonna be another bench warrant at some point. You'll be right back here, okay?
Right, for
Okay.
sure.
Okay, thank you. You're free to go. Have a good day.
You too. Thank you, sir.
And I have some bench warrants for the record, if I may.
Okay.
Romaine Mullen of case 082901 DP. Serenity Linwood of case 201677 DC. Therese Coleman of case 23439 DC. Terrence Heath of case 191886 DP. And Travis Hainaut of case 163090 DM. These respondents failed to appear for their referee hearings in front of the court. Requests that bench warrants issue in each of these matters pursuant to statute.
Okay, thank you. Court would enter bench warrants for Mr. Mullins, Ms. Linwood, Mr. Coleman, Mr. Heath, and Mr. Hainaut in this matter. As a result of their failure to appear at the respective referee hearings, the court would set their bonds in the amount of 25% of the outstanding arrears or $500, whichever is greater, and further would assess court costs of $150 in each case.
Thank you, Your Honor.
Okay, thank you. Have a good day.
Thank you. You too.
All right, take care, Jeff. Talk to you later.
See you, Jesus.
All right. Now we
Casey
can go to
Carey
our other
entering
things.
the chat. Merry
No, this
Christmas.
computer. I started the computer when I came in, then it just came up with an announcement. Your computer is going to restart, and then you have to hit restart, then it has to go all over and go, what is going on?
I don't know why they do that.
Oh,
Please
tell me
unmute
about it,
both
Judge.
of
It's
you.
so fucking annoying.
Hello.
Yes,
Hello.
Jesus.
Okay. Thank you for your patience. This is case number 2024-1167 DM. Chelsea DeWater versus Kenneth Bison II. It is Wednesday, December 18th, 2024 at 8:41 a.m.
This matter is before the court on the plaintiff's motion for entry of a default judgment in this matter. Court does.
Donald, you had a big crash, but you're okay? And you got a new car. Okay, thank you for the super chat. And I hope that you're doing well. Yeah, be safe. Drive safe. Did you get a new car that can drive itself? Question. But we're glad you're okay. And thank you again so much for the super chat. Also, yeah, the judge, I love the judge complaining about the same computer problem I have too. Sometimes this bitch just wants to restart and redo something. They used to give us time to choose, now they don't. Sometimes.
Have friend of the court approval and everything else. Mr. Isom, are you disputing or contesting anything in this matter?
No, Your Honor.
Okay, thank you. Mr. Water, I'm going to have you raise your right hand. We'll have you sworn in, then we'll proceed.
Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
Yes,
Okay. Mr. Water, do you have the script that we would have provided you?
I do.
You can go through that. You do not have to disclose your address, though.
Okay. My full name is Chelsea DeWater, and I am the plaintiff in this case. I married the defendant on June 20th, 2020 in Battle Creek, Michigan. I filed a complaint for divorce on April 19th, 2024. I lived in Michigan for 180 days and in Calhoun County for 10 days immediately prior to filing this complaint. When I filed my complaint for divorce, all the statements were true. All the statements in my complaint for divorce are still true today. There has been a breakdown of the marriage relationship such that the objects of matrimony have been destroyed, and there remains no reasonable likelihood that the marriage can be preserved. I do not believe there is any possibility of reconciliation. I am not currently pregnant. The defendant and I have 3 minor children together. Their names and ages are Kamaya DeWater, 6, Cornelius DeWater Isom, 4, and Cyrus DeWater Isom, he's 2. I have read all the terms of the proposed judgment of divorce, and I agree with them. I ask that this court grant an
Christopher, did she just say Cornelius? That she named the child Cornelius? Thank you so much for the super chat. You are amazing, my friend. But I'm pretty sure she did just say that she named a child Cornelius. Also that the children have different last names, it appears. Perplexing. I'm perplexed. But I'm thankful to Christopher. Thanks, Chris.
absolute judgment of divorce. Thank you, Your Honor.
Thank you. Court will find that the testimony does establish the statutory basis. There has been a showing there's been a breakdown of the marital relationship. I'm going to enter the judgment as submitted. The defendant, as appears, stated he has no objection to that, so we will get that entered. You are divorced. Best of luck to both of you. I hope everything works out. You're free to go and have a wonderful day.
Thank you.
Thank you.
All right, thank you. Let's go to next one.
Usually when they have minor children, they sort of like take a little more interest in that. The judge was just like, yeah, peace out. You're divorced. Oh, love you too, Christopher. Take care. Take care. I'll send you some pictures of the cookies I make tonight. I'm making a crumble dupe. Yes, Judge and Samantha, you heard that correctly.
Just a moment,
wow,
ma'am.
we're looking at the same thing.
Mr. Jones, his device is not connected. Oh, can please unmute both of you? Can you hear us?
I can. Sorry, it might be a little noisy. I have my son with me right now.
Okay, that's fine. So thank you both of you for your patience. This is case number now 2024-2646 DM Samantha Hausman versus Robert Westworth Jones. It is Wednesday, December 18th, 2024 at 8:45 a.m.
This is the time and place set for the scheduling conference. This is where we put in place various dates and processes so that the case would proceed in an orderly fashion. So I'll go to the plaintiff first and then go to you, Mr. Westward Jones, in this matter. What issues, ma'am, do you believe are in dispute in your case? Ma'am, can you hear me?
Yeah, I can hear you. I guess, what do you mean by that question?
Well, in any case, there's disputes or there's no disputes. So I'm asking you what the disputes are between you and the defendant in this particular matter that we have to get resolved.
We agree on most everything.
Okay, I want to know what you don't agree upon then.
We don't agree on custody.
Okay. I will put no agreement on custody, support, or parenting time because they're kind of interrelated. Do you have any disputes on property division?
No.
Do you have any disputes on spousal support?
No.
Okay. Mr. Westworth Jones, do you have any other disputes than she stated under custody, support, and parenting time?
No, just the custody.
Okay. Are you going to need any discovery? And discovery is the process whereby you acquire information from the other side through the use of interrogatories, requests for production of documents, depositions, whatever. Do you anticipate, Ms. Hausman, any discovery?
Yes.
Okay. Well, what the court will do is cases early on. What I'm going to do is give you until I'll give you till March 1. That will by far give you enough time You'll have to have all of the discovery concluded by that time, though, and I will not extend it because that is sufficient time for you to get that done. So,
I'm sorry, Your Honor. Are you able to say what the discovery is again? My son was screaming and I could not hear it.
discovery is the process whereby you acquire information from the other side. You can do it through interrogatories, which are questions that have to be signed under oath. You can do a request for production of documents, request to admit, depositions, etc. Anytime you're trying to get information from the other side, you can use a discovery vehicle to accomplish that.
Okay.
And you'll have to do that by March 1.
Okay.
The court will therefore then set March as the mediation month, where you would meet with an attorney mediator. There is a cost associated with that to attempt to resolve the case. I'll go to Ms. Hausman first. Ms. Hausman, do you have a recommendation for a mediator?
I do not.
Okay. Mr. Westworth Jones, do you have a recommendation?
No, not really, besides a cheaper one, because the last one was $500.
What do you mean the last one?
We tried to go through with a divorce case before, and they wanted $500 from, I think, both of us, and I didn't have it being a single dad, so I had to drop my case.
Well, we'll send something to the mediation clerk and ask if they wouldn't, there are some services that provide some assistance based on income, et cetera, so they have a graduated scale. So we can attempt to do that.
Okay, yeah, anything that would help in that regard would be a lot of help. Thank you.
Yeah. Court will set April 7th, 2025 at 1:30 p.m. as the date for settlement conference. And parties are required to be present, so you'll have to be there. It'll be by Zoom like this, but you'll have to appear. If not, you could be defaulted or the case could get dismissed. So, any questions, Ms. Hausman?
I do not. Thank you.
Okay, we will send this out to you. Any questions, Mr. Westworth Jones?
No, I do not. Thank you.
Okay, you'll get the order. There are dates in that order that you need to comply with, so make sure you do, because you don't want to be prejudiced if you miss a date or something of that nature. So, okay, thank you. You're free to go. Have a good day.
Thank you.
All right, thank you. We're going to close it here.
I don't know whose child that was. What a weird little case that was. But he certainly did like bringing up that child. Both literally and figuratively. She says obnoxiously. All right, speaking of obnoxious, watch how fast this case is going to start. Seriously, I'm barely going to have time to mute myself before they fucking beak off. Let's roll.
We've provided the court with the contracts, with detailed billing statements. There's no dispute that there's balances owed. So I do believe we've met our initial burden. I don't believe that they have met their burden based on MCR 2.116 G4 in the Quinto case cited for the court, which states that once the burden is shifted to the non-moving party, they've got to come forth to the court with something more than mere allegations. They have not done that. They haven't provided this court with anything to raise a genuine issue of material fact. The only defense that they've really even provided to this court is based on this alleged first material breach. There's this defense is problematic for several reasons. First, they haven't filed a counterclaim for breach of contract. They didn't plead first material breach as an affirmative defense. There is no contractual obligation that invoices are sent at any particular time, so there really is no breach. They haven't provided this court with any verification or anything, documentation showing that there was a delay in the invoicing. At this point, it's just a mere allegation that they're making that there was some delay. They haven't provided this court with anything to support that. And even if we forgot about all of that and let all of that slide, a slight delay in invoicing would certainly not count as a material breach of this contract. So the only defense they've provided is this idea that there was some delay in the invoicing and somehow that amounts to a material breach of the contract. It really doesn't raise any genuine issue of material fact. They haven't met their burden. We do believe that we've met ours, and we ask the court to grant our motion today.
Okay, thank you.
It's like a tidal wave when we have a special number change. Thank you, Cellulite Yoga Pants. Thank you, Beverly Bradford. And thank you, MB. Me too, me too, me too. I love you guys. You rock. Also, I was like furrowed brow there trying to get this to work, and I didn't realize in my struggle to cover up the child I had moved the chat around. Anyways, let's continue. The judge does love his civil cases. Civil baby.
Mr. Monsma, go ahead with whatever you want in your response.
All right, thank you, Your Honor. Counsel raises the court rule, and of course that requires the plaintiff, in this case, the movant, to present evidence in their support. I thought it was notable they didn't include any affidavit in their motion that the work was done. In fact, they didn't include any affidavit at all. They just gave you the engagement letter and some invoices. There's no evidence that those were even sent or when. There's no evidence that the invoices were not paid. And of course, we suggest in our discovery responses, which were provided, that they have been paid for all work that was actually done. We also presented evidence in the form of our discovery responses that the invoices were delayed by months, not some minor delay. They were delayed by months. They didn't get some of these invoices in some cases until the relationship had been terminated. So in our view, that's a material breach. And I think at worst, that's a question of fact that needs to be resolved at a trial. I'll also note we didn't have the opportunity.
Let me address that, because that was something big.
Sure.
I note in your response that you had asserted in paragraph 4, your response said plaintiff's failure to send defendant invoices for months on the work that was allegedly performed thereby constitutes a first material breach in this dispute. Explain how the failure to provide the invoices is a breach of contract, in that when I looked through the contract, the agreement, I didn't see anything. It said that they would provide invoices. It doesn't say it's required. And I guess in that regard, I look at it and say, if I followed your logic, I'd say, okay, what happens if they're providing invoices all along and something happens? They have a computer system go down, or attorney's on vacation, or staff is on vacation. They don't provide an invoice for that 1 month. It sounds like you're saying, well, that obviates the requirement to pay anything on any subsequent invoices.
I'm not arguing that, Your Honor, to be clear. What I'm saying is, the question is whether a breach is material. If you want to get paid for invoices, you obviously have to send them. And if they did not send them for months and months and months, which is what we contend, and we present evidence to that effect, that could be, in the view of the trier of fact, the first material breach. I think you could also describe it differently as maybe a prevention of performance, right? We can't pay invoices unless we have them. And so what I was also going to say, Your Honor, and I want to flag this, we didn't have the opportunity to take Mr. Hilderly and Mr. Yatuma's depositions until yesterday. And I point that out only, I'm not casting aspersions on anyone. My only point is we didn't have the benefit of that testimony when we filed our response. And I can tell you, they both testified yesterday, among other things, that they can't tell you exactly who did the work or if they did the work that's outlined in the invoices. And specifically what I mean is, and you can look at the invoices, there's multiple entries for LA as a timekeeper. According to Mr. Yatuma, that means legal assistant. And when I asked him who did the work, he told me I couldn't tell you. You'd have to ask them. So my point is, I think at worst, there are fact questions on that as well. And then that also gets to the question of damages. Our position is that a lot of this work wasn't done. It wasn't approved. Their own admission in their deposition is they can't even say for sure who did the work. I think at worst, there is a question of fact about their damages. And so for all of those reasons, we would ask you to deny the motion.
Well, in this particular matter, the court does note too in this case that your kind of your recourse too. You say, well, it's the first material breach, but the fact remains under the agreement, it does provide that, again, when the invoices are provided, that you have 7 days in which to raise a dispute as to the invoices from the date of service. And court notes in looking at that, I don't see anything, and I haven't seen when I look through the discovery documents, I don't see where your clients had provided any dispute in writing as to the invoices. Do they have disputes in writing that they provided?
Well, I think that gets back to the same issue, Your Honor, the timeliness issue. They obviously can't object to invoices that they didn't get.
Well, I understand that, but when they got them, they're saying we sent these invoices out and they were, they referenced them in their discovery at the time that you got them. Let's say you didn't get them for 2 months. Well, then at the end of the 2 months, let's say you got 2 invoices. Well, you have 7 days in which to dispute them. And I don't see anything in your response or any other documents that show you provided proof of a dispute in writing. And pursuant to that provision of the contract, it says if you don't do it within 7 days, that provision, that you waive any dispute after 14. If I've got that correct, wouldn't it?
Yeah, Your Honor, and I think.
I'm sorry, within.
This is my amazing apron that Cellulite Yoga Pants made me. And it includes not only the best, biggest pockets around, and it's hand sewn very well, but handy dandy pen holder. That's right, sewn right in here. I love it. And I'm doing a lot of cooking or baking today. So I was getting myself in the groove of that, even though I have to go out before I can get down to it tonight. I need like 3 major ingredients. Anyways, also, I just love it so much. Thank you. Yes, the magic vape pen pocket, and handmade by our very own Cellulite Yoga Pants. One of my prized possessions.
7 days. Within 7 days, it's forever waived.
Yeah, and I think before you get to that point, though, Your Honor, they have to establish as the plaintiff with the burden of proof that the work was done and who did it. And they admitted yesterday under oath they can't do that. So again, I think there are questions of fact that need to be resolved at a trial here. They have the burden of proof. They have to establish the work was done. They didn't submit an affidavit. They just submitted these invoices, when they admit under oath in a deposition, they can't even say who did the work. And it's the vast majority of the work, I'll note. Most of these entries are for somebody LA, but they've admitted they don't know who that is because it could be any number of people who supposedly did the work. So I would respectfully push back on that a little bit because I think it skips over their burden of establishing that the work was even done in the first place.
Also, the sweater I'm wearing was also a gift.
Okay. And that would be obviously what you stated in page 4, as you said, your comment is merely sending invoices months later does not satisfy plaintiff's burden of establish that the work was actually performed. Is that what you're?
I think that's exactly right, Your Honor.
Mr. Hilderly, what's your response?
Thank you, Your Honor. Just briefly, as to the lack of an affidavit, this was a verified complaint in that we did submit affidavits verifying the work and the balance owed as part of the complaint. So I don't agree that there is no affidavit in the record. And just briefly, I think Mr. Monsma is slightly mischaracterizing the deposition testimony from yesterday. Both myself and Mr. Yatuma, what we said is that by looking at the invoice, you wouldn't be able to tell who the LA is because it's not really important for purposes of the invoice. But what we said is that the legal assistants do input their time individually. So that information could be provided if for instance, within 7 days, they questioned or challenged a bill, then we could have said, oh, yes, let us look into this, and we could have seen who entered that time. So he's slightly correct in that we both said from the invoice, you can't tell the legal assistant that did the work, but we could provide that information if it were necessary, which it really isn't. But that information is obtainable had they sought it or objected. But I don't think it's terribly relevant for this afternoon.
Okay.
Well, Your Honor, I would respectfully disagree with Mr. Hilderly. I think it is pretty relevant if you can't even say who supposedly did the work. They're asking for $100,000 judgment today on the basis of a few pages of invoices that they admit don't tell you who actually did the work. And so I think that alone is a fact question for the trier of fact. And when Mr. Hilderly says the information could be provided, I would, again, respectfully suggest they should have provided that as part of their motion. In fact, they have that obligation as the plaintiff and the moving party. So again, I think there are questions of fact here, and we would ask that the motion be denied.
Well, I am, of course, troubled a little bit the fact that the depositions just occurred yesterday, and I don't have the benefit of any of that. Mr. Hilderly, if you stated it would be very easy to provide information as to who the legal assistants were, if the court ordered that you would provide an affidavit delineating who those assistants were and for what work, how long would it take for you to prepare that? Recognizing I'm asking you because of the holidays.
Yeah, that's what I was.
I don't know who's gone or who's there or what, so I don't.
I would say that we can probably do that fairly quickly.
14 days, 21 days?
Yeah, I think 14.
Okay.
Then, Your Honor, could I ask for a chance to respond after
Yes,
they submit that?
We'll give Mr. Hilderly 14 days to provide an affidavit delineating who the legal assistants were and what work was performed by them, by the particular individuals. And the court will allow you then, Mr. Monsma, another 14 days to respond. And if in fact, what I'll do is allow both of you, based upon the depositions in this matter yesterday, and maybe that'll make a difference as to the dates we're doing. If you want to supplement your briefs in this matter to bring up that information from the depositions, I'm willing to allow you to do that. With that, Mr. Hilderly, is that going to take you longer than 14 days to get the transcripts and then respond? I'm not saying you have to. I'm just saying if you wish to, because I don't have the benefit of those depositions.
I do have those. I have the transcripts from the defendant's depositions already, Your Honor. The real question would be the transcripts from the ones from yesterday. So I'll let Mr. Monsma item.
Yeah, I mean, I would imagine, I'm just looking at my calendar, Your Honor. Next week we have one working day, I think. I guess there's a couple after the holiday, but I don't know what the court reporter is going to do.
Maybe Mr. Hilderly, rather than 14 days, if we gave you 21 days, could you then supplement your brief if you feel you need to? I'm not saying you have to. I don't know what happened yesterday, so why don't we give you 21 days, and then Mr. Monsma will give you 21 days to supplement your response in this matter as well. The court will take the motion under advisement pending the receipt of those documents, and then the court will make a ruling at that time.
All right. Thank you, Your Honor.
Thank you, Your Honor.
Anything else, Mr. Hilderly?
For clarification purposes, Your Honor, we won't have another hearing unless the court asks for one at this point.
Yes, at this point. Yeah, the documents, because you'll have a chance to submit those. Mr. Mons might have a chance to respond. And, that, I guess what that way is it eliminates a lot of the disputes that appear to be, I don't want to say potential fact questions, but potential fact questions.
Okay.
All right. Thank you. And just
thank you, gentlemen.
Would you like us to prepare the order, Your Honor?
Yes.
Okay.
So Judge, are we resetting this motion for another day?
Nope. Okay, gentlemen, have a good day and a good holiday.
Thank you. You too, Judge.
Thank you. You too, Your Honor.
Happy birthday, Lisa B. I didn't realize it was your birthday. Happy birthday. Happy birthday. I hope you have a wonderful one. I hope that you guys are excited for the upcoming holidays. I know Hanukkah and Christmas fall on the same day this year. That's unusual. We're so excited about that. Everybody gets to celebrate together. I have to go buy some more ingredients that are dancing around my brain because I'm making almond crescents, ginger cookies, chocolate chip cookies, Rice Krispie squares. Now, as I repeat this, it sounds too much. I already bought all the ingredients mostly. I only have like partial, like a few little things. So those are the things that are happening. Happy birthday to Lisa. Okay. Give me 1 second. Happy birthday to you. Happy birthday to you. Happy birthday, dear Lisa B. Happy birthday to you. Also, I have to go I bought bacon yesterday. The cost of butter, tell me about it, Cellulite Yoga Pants. Do you know how much butter costs here? Even the cheapest butter is $5.78 per pound. And we don't really sell sticks of butter. They all come in like a solid pound. And so $5.78 is the absolute cheapest, but like that's, at a grocery store that's not Walmart, $7, $8, easy for a pound of butter. I've been buying up butter over the last like 2-3 weeks. So I have 4 pounds of butter. 4 pounds of butter to fit in my mouth. No, I'm not going to be eating all of these treats that I'm making. I will be giving them to people. The almond crescent cookies are really, really, really delicious, and they're I'm very excited about that. The chocolate chip cookies is my standard. Oh, butter pats. The chocolate chip cookies are delicious. Delicious. Anyways, guys, thank you so much for being here, helping me through my laundry list of items that I need to get. I appreciate it. I appreciate each and every one of you. Reminder that I love you and I'm proud of you, and I've set up this stream to redirect over to Colin, so have a good night over there. I love you, I'm proud of you, and I'll see you in the next video. Okay, bye!
Ways down and ready to